So one of the questions that I get often related to trust planning is who should serve as a trustee of the trust? And the very short answer is someone who's qualified. So let's talk about what that actually means and what that can look like. So let's get into it. So what does it mean for someone to be qualified when it comes to serving in the trustee role? So first, the trustee is the person or the entity that's responsible for administering the trust. And I'll talk about what that means here in a second. So as the name kind of implies, it needs to be someone that you trust, but not only someone or an entity that you trust, but it needs to be someone who's qualified. So there's a certain background or technical acumen that I think lends itself to being a trustee of a trust, but you need to think about it in terms of what are the responsibilities of the trustee. So the trustee kind of break it down into three different things. First, it's someone who are, again, an entity. I'll just keep saying someone, but it could be a corporate entity, but it's someone who can administer the trust. That means make sure that the trust is being administered according to its terms, according to the provisions that you find inside the trust. It also would include putting together tax documents or tax returns or sending out what's called crummy letters. I won't describe what that means, but there's just different things that a person or someone has to do as trustee. Something else along with administering it is also distributions. They're in charge of the distributions to the beneficiaries. So the distributions would be, whether it's income or it's principal, the assets that were placed inside the trust or accumulate inside the trust, where there's some distribution provisions inside the trust, and the trustee is in charge of that. And then lastly, the management of the assets as well. So it could be a brokerage account, it could be an operating business, cash accounts, different types of things, Bitcoin, oil and gas business, ranch, farms, etc. So a lot of different things can go into that. But the point is the trustee is someone who has a skill set to be able to do all of those different things. So there's going to be tax consequences, accounting consequences, legal consequences, and someone needs to be able to wrap their head around that entire thing. Some trusts are more difficult to administer and manage than other trusts. So, it's some are a little simpler than others. So that's something to consider. But because of all the different nuances and the different legal, accounting, tax implications that are related to administering a trust, you have historically seen a trustee, a trust company named as trustee. And so the reason for that is usually they have a team of people who have these different backgrounds that I just mentioned. And so a trust company can be a standalone trust company, or it could be a trust company that's associated with a bank. We see a lot of those. And again, they have this background to be able to do all these different things, all these administer and adhere to all these responsibilities that they have to carry out the terms of the trust. So that's why it needs to be someone who has a qualified background. And not a lot of people, not a lot of lay people have the background to be able to serve as trustee and to serve as a trustee really well. And so you'll often see parents who leave a trust to their children. It may be one child or multiple children, but they'll name one of the children as trustee. And that can work. But it could lead to family problems, family squabbles, that, sisters, brothers get upset with the one sibling who serves as trustee because they're not doing this right or that right, or what the beneficiary perceives as right. So there's other things also that, if the trustee lets certain things fall through the crack, it could compromise the integrity of the trust from a tax perspective or even an asset protection perspective. So all of a sudden, maybe you did something incorrectly, and now there's a negative income tax consequence, whether to the trust or to the beneficiaries, or maybe there is a negative estate tax or generation skipping tax consequence, a wealth transfer tax consequence. So if you don't have that background or you're not talking to the right people to give you insight, then you could have, a serious tax issue. The other thing is asset protection. So if you're not administering the distribution and managing the assets of the trust correctly, then you could compromise the asset protection of the trust. And if you're interested in asset protection, I have videos about that, so check out some of the other videos. but I won't go into detail about how all of that works. Just know there could be negative tax consequences and asset protection consequences. So in the last 20 years, we've seen more modernization and updates to trust laws than we've seen in the last 200, 300, maybe even longer years. And one of these modernizations has been what's called directed trust. And so we're going to talk about what a directed trust is, and I have a slide that I want to share with you because I think it's helpful to see all the different roles that you can actually have in an irrevocable trust. But a directed trust is actually the bifurcating or trifurcating of the traditional trustee responsibilities. It's part and parceling out all of these responsibilities that one person or one entity, trust company, has been responsible for adhering to or carrying out rather. So let me share this video, let me share this slide with you, and then we can kind of get into what this really looks like. So this is a presentation that I've put together that actually discuss directed trust. And this slide in particular is dedicated to directed trust structures that are allowed under South Dakota law. A lot of different states do have directed trust laws, and a directed trust is just an irrevocable trust, but a directed trust describes how that irrevocable trust is set up or how you part and parcel those different trustee responsibilities. So you'll see in the middle here that we set up a dynasty trust. It could be a dynasty trust, a descendants trust, an inheritors trust, just an irrevocable trust that you're setting up for the benefit of someone else. Typically, parents are going to set up this type of trust for the benefit of their children. And so you'll see the dynasty trust in the middle of the page here, the middle of the slide. Then we have 5 different roles here: family advisor, trust protector, distribution advisor, investment advisor, and administrative trustee. So with a South Dakota trust, and I have other videos about why I love South Dakota and why it's the best trust jurisdiction in the United States, and why clients in other jurisdictions, even abroad, consider South Dakota. I won't go into detail about that here, but this is one of the reasons why, not the exclusive reason why, but one of the reasons why, because the person setting up the trust now has more flexibility and control of the trust than they've ever had in the past. Kind of the knock on an irrevocable trust has historically been that once you set it up, you set it and you kind of forget it. That you're locked into it. It doesn't provide much flexibility. But with the directed trust structure, you really do have a lot of flexibility. So with the administrative trustee, I'll start there and we'll kind of work our way around. So the administrative trustee, to have a legitimate South Dakota trust, you need to have a resident trustee of South Dakota, whether that's an individual or that's a trust company. So most people don't know someone in South Dakota, so they use an administrative trustee, they use a trust company. What's unique about the trust companies in South Dakota compared to a lot of other states is that the trust companies there, a lot of them, I don't know if it's necessarily most of them, but a significant amount of them don't actually hold assets. They're non-depository trust companies. So they're not interested in managing your assets. So your traditional trust company is going to charge a percentage of assets under management. So maybe it's 1% of whatever assets you have held in the trust. So those fees they can become pretty significant. Most administrative trustees will charge a flat fee each year, and they're only charging for that administrative function that they serve. So the trustee technically owns the assets of the trust because they're the person or entity that's designated as trustee. And you'll see here I have some bullet points. They prepare in trust documents. They maintain bank accounts. They prepare trust statements. They actually make the distributions to the beneficiaries, and they receive any contributions. So anytime that someone's making gifts to the Dynasty Trust, then they'll make it to the administrative trustee. Um, the administrative trustee actually takes direction from the distribution advisor and the investment advisor. And you can kind of consolidate some of these responsibilities. Sometimes you'll see the administrative trustee also serve as the distribution advisor. The distribution advisor, and we'll jump over to that one. And you see these 3 roles directly underneath the dynasty trust. So the distribution advisor and investment advisor can be structured as committees. You can have more than one per person in that role. But the distribution advisor is simply responsible for deciding when to make distributions to the beneficiaries. They don't actually, hand the check or wire the money over to the beneficiary. The administrative trustee is in charge of that. But the distribution advisor tells the administrative trustee when to make that distribution. And the administrative trustee has to do that. So you could name a family member, you could name multiple family members, you could create, again, a committee where you're having maybe trusted advisors serve on a committee with maybe other family members. So there's different ways to approach that. The point is maybe you're taking that and giving it to people who really know the beneficiaries and know the beneficiaries well and know when they might need those distributions. The next is the investment advisor. And this can be your financial advisor, your wealth management advisor. It can be your actual investment advisor. And these, I should note that these roles are actually defined by law in South Dakota. So investment advisor is the actual role that's defined. That's the title that South Dakota law gives to this particular role. But this is the person that's in charge for managing the assets. So a lot of times, this most significant assets in a trust will be a brokerage account or investments, financial investments, and families will name their investment advisor or their wealth management advisor, their financial advisor in that role. So the idea behind that is the family is then able to continue to work with the advisor that they've had a long-term relationship over many, many decades. Now that many, many decade relationship can become a multi-generational relationship rather than going and using a trust company if you haven't historically used a trust company. Some clients will use a bank and trust company their entire lives. And so, that relationship will make sense for them over multiple generations. But if you haven't done that, then this directed trust structure can make a lot of sense for you. So we talked about the administrative trustee. They take direction from the distribution advisor and the investment advisor. But again, you're putting the people in there that you trust most, who you think are the best qualified specialists to serve in those different roles. Next is a trust protector. The trust protector is that role. You cannot name someone who's a family member, and you can't name someone who is subordinate to you, meaning that they're actually on your payroll, like they work for you. And you can't do that because it compromises the estate tax issues. It will present estate tax issues, and then it would compromise asset protection. So you want to make sure to name the right person, the trust protector. But that trust protector role is really important because that's what gives you flexibility with an irrevocable trust. That trust protector can amend an irrevocable trust. They can update the provisions. Maybe there's a change in trust laws or tax laws or family circumstances, whatever it may be. You may need to loosen distribution standards, or maybe you need to tighten distribution standards, or maybe you need to assign assets in that original trust to a different trust. That's called decanting. So all these different roles have a fiduciary standard, so they still have to act in the benefit, in the best interest rather, of the beneficiaries. So all of these work together in one cohesive way, and they kind of are a balancing act to make sure that one particular role doesn't have significantly more power than another role. That way there's no abuses or anything like that. And you can include, one thing I think that's kind of interesting is that you don't have to name a trust protector, but you can go ahead and include trust protector provisions in your trust. So you may not know the person that you want to name now, but you can name them further down the line, or you can give someone the ability to name that trust protector further down the line. The other role, I should say this, the trust protector, distribution advisor, investment advisor, administrative trustee, those roles do exist in states other than South Dakota. The caveat is that not every state has well-defined laws around these different roles. And what you might run into is that there might be too much legal risk for someone or an entity to take on serving in these different roles. But because South Dakota has very strictly or very narrowly written their law related to each one of these roles, it's very clear what you're taking on and what your responsibility is, and then you can further define it in the trust document. Um, some states, they may not have directed trust laws, but you still technically could do a directed trust. The problem with that, though, is that the trustee is going to be, they're going to, because of common law, and I won't go into what that really means, but because of common law, the trustee in a jurisdiction that doesn't have directed trust laws or well-written directed trust laws, that trustee is going to be responsible for the distribution advisor, the investment advisor, the trust protector, the family advisor. And no one wants to take on that responsibility of all of these other actors that you're naming. Whereas in South Dakota, each actor is responsible for their exclusive actions. You're not responsible for anyone else. So that's why South Dakota is so important in this. Lastly, I'm going to say something about the family advisor. This family advisor role is unique to South Dakota. And a lot of times you'll see someone name their attorney or their CPA, different type of advisor in this role. And the family advisor really oversees all the other roles. And you could name the same person in the family advisor role as you do, say, the distribution advisor role or the investment advisor role. You could even create a new entity, a special purpose entity. You can have a committee in that family advisor role. But the point there is to have someone who can continue to be that main point of contact um, for the family and with the trust to make sure that the trust is being the original intent of the trust is being carried out over multiple generations. So it just adds an additional layer of expertise to the directed trust. So all of this together, why do all of this? Again, because it gives you the hand selected specialists, the hand selected professionals that you think are best at their jobs and know your family really, really well. And it gives you more flexibility, but it also takes away all of these different roles from your traditional trust company. Traditional trust companies can work for some people, they work great for some families, but for some families, they've chosen not to go that route for one reason or another. And this approach kind of allows for a family office type of structure where you're choosing your investment advisor, you're building out your trust protector role, your distribution advisor, the administrative trustee, and maybe even a lot of people will name their family attorney as the family advisor. It could be someone else, but all of a sudden you have all of your different handpicked professionals serving in all these various roles. It gives the family a lot more flexibility. It takes away the need to have one trust company that decides everything. And a lot of clients are really looking for that. So it really is a matter of taking control and flexibility back into the client's hands. So when you're looking at how to accomplish what you really want to accomplish in this type of directed trust structure, it makes sense to look at South Dakota.